have more than 50 years of experience in the field of arbitration, and that's the galaxy of speakers who are present today before us. So may I now invite first Ms. Zarina Chinoy, who is the in-house general counsel for Shapoorji Pallonji Group. And when I had a word with her, she said that my expertise is to see that no litigation comes before the court. That is, she gives advice in such a way that the employer is having least possible kind of innings before the courts, and that's a wonderful achievement. She also told us about the consolidation of arbitrations, which she steadfastly tries to impress upon. And third area which perhaps she also may like to throw light on is the interim award, or what we call the emergency arbitrations. So may I now invite Ms. Zarina Chinoy. Yes.
Thank you, sir, for your very generous and kind words. Good morning, everyone. So just to start off with what I really look forward to in my company is, as he said, I prefer to minimize the exposure of my group to litigation. Now, the reason obviously is in India quite evident, because the courts are overwhelmed, the cases are plenty, and especially in my case, where most of the construction documents are voluminous, projects take anywhere between 3 and 10 years. Witness evidence is here and there. Documentation, again, is sort of willy-nilly. These things, if I were to take it in front of a court, how long would I take? How expensive would it be? Would I be able to even see the outcome before I retire? These are some of the considerations I myself come across. So as we've seen along in most of these construction contracts, all of these big construction contracts today, either with the government or with private institutions, other players, contain arbitration clauses. These arbitration clauses, if they come by me, we very carefully word them. We word them to try and consider the seat, the venue, the law, the jurisdictions, what kind of courts would be there, the amount, the number of arbitrators that we have to consider depending on the claims that we probably have. We try at the outset itself to determine what our problems will be, right? They're all lawyers. We hope for the best, but we prepare for the worst. That's what we do. So in our contracts, that's exactly what we do. So sometimes I get a question from the opposite side saying that, are you preparing for a divorce before we even get married? Unfortunately, that is the case. We always do have to prepare for that, which is where we try and draft all of these clauses with particular care. And one of them is the institution with which we have to go in for the arbitration. What do I necessarily consider the prerequisites in that clause? What would I want in an institution? I would want the arbitrator, the appointment of the arbitrators to be easy, to be quick, impartial. I need that the arbitrators have the kind of knowledge and skill sets that we require when we start looking at these voluminous documents. I also would like to see that the arbitrator has time, that he or she would be able to dedicate the necessary amount of days or weeks that we require, that they have the fundamental knowledge of the procedures. I mean, we don't need to start drafting procedures from the outset if the institution at least gives them some sort of guideline or background to what it can be in terms of discovery of documents, how we treat witnesses, what is the evidence that can and cannot be put forth, how is it supposed to be put forth, what the terms of reference will be. All of those things are definitely considered at the time that we put in this clause in terms of the name of the institution itself. Tejus, you can of course speak to more in terms of your rules so that you can highlight those. As a group, we also want that the award comes quickly. We cannot wait indefinitely. Even a period now, today, sometimes arbitrations do take We have in our Arbitration Act that it's supposed to be completed within 18 months. In some cases, just going by our documentation, I know that that's not even a possibility. But at least there has to be some sort of time slot. I can achieve this maybe within a period of 3 years, whatever it be. I need to have certainty, or at least the light at the end of the tunnel has to have a number of years that I can count on. So that's another aspect why we generally tend to prefer institutional arbitrations over this. In terms of actually appointing emergency arbitrators, as you've said, sir, if we see that there is a possibility of us maybe going through an entire arbitration without us at the end of it being able to enforce the award, or where we see that the other party is going to or has an inkling to disassociate itself with all the necessary assets that we need for enforcement, then of course we need that right to be able to protect our interests in this case, which is why emergency arbitration today, in today's day and age, in today's financial world, has garnered so much importance. And I believe our Supreme Court has also made it clear that this is a very possible thing under Indian law, and that we can, even with Indian arbitration seated in India, have this right to do. We look at this, but it is a tactical measure. We invoke it where necessary. We deem it necessary, as I said, if we find that there is a possibility that we won't be able to, at the end of this journey, be able to execute the award. So a lot of this goes into our planning, into our thought process when we draft documents, when we draft these clauses, and the outcome may not be certain, it's not definite, right? But at least there should be some amount of fairness, some amount of exposure in terms of time. What am I looking at? I have to have some concrete numbers in my hand to be able to go ahead with this. Thank you, sir.
Thanks, Ms. Chinoy. Ms. Chinoy is a well-known expert who guides the course of litigation in Shapoorji and Pallonji. So we have had the perspective of somebody who repeatedly is party to certain arbitral transactions or procedures. And therefore, having learned from the experience, we have now what is called chiseled approach to the process of arbitration from a side which normally appears as a party in arbitration. I will turn to our next speaker, who is Mr. VP Singh. He is an alumni of National Law School, Bangalore, a prestigious institution in the country. And he has been in the field of arbitration for last almost more than 20 years. He has seen the matter from the perspective of appearing for the clients, appearing for the parties, in and out of courts, before the arbitral proceedings, before the arbitral tribunals, as well as in any kind of challenge procedures before the courts of law as well. So his experience is a varied experience, a diverse experience, who has seen the coin from both the sides. May I now invite Mr. VP Singh to share his views in the matter. Green.
Is this better? Yeah. I believe the arbitration clause is like a tadka or a seasoning. It's the last thing in a contract, and it's the first thing that you will experience or taste once the dispute happens. And unlike the rest of the contract, which you actually will perform with the going is good, the arbitration clause is the only divorce clause in the agreement. So you have to provide for risk at a heightened sense, and where people may or may not cooperate. Therefore, it has to fulfill the 3 E's, as I call it: efficiency, economy, and effectiveness. Why? Because if you are able to fulfill a contractual promise by making sure that it's enforceable, you bring about ease of doing business, and more importantly, you bring down the cost of doing business. When 50% of your contracts are enforced, the cost of doing business is higher than when 90% are there. In no universe will you have 100% enforcement, because you will have the stray, the outliers as I call it, but the outliers prove the rule rather than are an exception. The issue that we need to see is how in our present panel do we see the proposition? And it's out there for all of us to say whether that question mark is a complete full stop or is there more to it. And when we look at that, and it's in that context that I want to address you on how do I see arbitration. I see arbitration as a supplement to the process of dispute resolution available in courts. And I see it as a supplement because it allows for access to justice while reducing the pipeline of matters that go to court. We can choose to turn on the tap and no one stops us from doing it. But then don't have an arbitration clause. If you want a second appeal, you want a first appeal, you want a second appeal, please go ahead and do that. I'm not someone who's going to judge you. Banks, for instance, stay away from arbitration clauses because banks are very clear that they have a specialized fast-track resolution mechanism. And they will take the shots with it. As opposed to this, you have, and insurance companies may at times want to keep out on smaller contracts. But the fact still remains that if you want to get into arbitration with the mindset that you will keep out of court. And why is that important? Because an institutional system, unlike an ad hoc system, clarifies that mindset in express terms. It says you should be careful what you wish for because it may come true, which is why it says in case there is a determination whether from an emergency arbitrator stage or an award stage, it will be given the due credence and it will be final qua the parties, subject of course to whatever the law allows as an oversight over the mechanism and not an appeal. And I believe that this is important because I do believe that it helps cut down what I call dilatory tactics at a time when parties are not necessarily aligned. You may have different interests, but the divergence is maximum when you've actually called out someone's fault. So institutional arbitration effectively vaccinates the process against dilatory tactics and is effectively what you would call an answer to guerrilla non-cooperation that takes place regularly, and I've been guilty of it, and I'm sure all of us have had their own chance in playing that tactic out. The other thing that it does is not only does it vaccinate against this, it also vaccinates against any challenge on confidence. The confidence can be by way of keeping dealings confidential. It could be by way of conflict of interest. It could be by way of impartiality and availability. And in such a situation, an institutional perspective ensures. And we've got three institutional players here. We've got Tejus here, we've got Abhinav, we've got Chauhan. All of them have helped their respective institutions come and cater customized dispute solutions for the market. And you've been able to do that because you speak to the market, hear from the market, customize it, and you put it in a clause in an arbitration set of rules which carry a global perspective, but are able to provide for local problems. And they do so maybe by a 32 or a 40 article or regulation clause, which is your dispute resolution clause. Now, if someone's done that hard work, being as lazy as I am, I would definitely want to go ahead and take that and add it to my agreement. Why? Because if I want to provide any customization, I can always provide customization, but I don't need to provide for everything. I do not need to draft out a CPC for my dispute process. That's what an institutional arbitration clause effectively does. It ensures that the exuberance of getting to the end of the line does not come in the way as disappointment when it comes later. Then there is the issue of ensuring conduct and sanctity of conduct, where you have natural justice provided for, but not lose sight of the fact that at the end of the day you want justice. So dilatory tactics, walking away. You have Article 26(2) of the ICC rules, which says you will give everyone a chance to say their piece, but it will not be an endless chance. It's a reasonable avenue. And I don't think that takes us too far away from how we would deal with it in court. So if we have this provided for, in an ad hoc, you can also do it. But every time you do it in an ad hoc, all of us have seen enough 227 challenges which bring you to a court in a writ jurisdiction, take up court time, allow you to not really get on with your arbitration, on the understanding that you have a shot at selling natural justice at any point of time. And the reason why we can do that is because Indian courts today are not charging people the costs that are incurred in defending these proceedings. It is definitely a cost arbitrage available, because if I play this out in court, I may get away with a rap on my knuckles which is cheaper than when I play it out in an arbitral tribunal where they will actually take note of it and say, okay, be careful what you wish for because it may come true. I will decide this point, and if I decide against you, I will also make you pay for it. Now that is something which brings me to my next point, which is costs. Costs can be in terms of time, as Zarina correctly pointed out. It could be in terms of the activity finally paying out its desired result. Or it could be those which are sunk into the activity. And that's what an institutional arbitration system does. It actually turns around and says, I will account for it. I will ask parties for deposits. I will ensure that deposits are accounted and a reasonable statement of expense is given, and close it out by saying, this is how I tax it. And taxation is real. It's no longer left to the scales that we find in court. With the exception of the Delhi High Court, which has now moved to, on the original side at least, a real cost system, we still need to take a look at our cost system. A cost under the Supreme Court was 10,000 rupees for an arbitrator for the counsel's fee. You can go to the Supreme Court and access the Supreme Court by way of an appeal for 5,000 rupees. But when you go to an arbitration and you access that arbitral process, you will have to pay on the basis of what you say. So if you want money, you have to give money. And that becomes an effective deterrent against high-pitched claims. There is no such deterrent in ad hoc arbitrations. It only becomes a guide towards what the fees would be for the arbitrators. But in an institutional arbitration system, you actually have that as a filter. The next point that I believe the institutional system does is actually allow for party autonomy in the true sense. It allows for what I call dispute resolution sandboxing. You try ideas out. You try out, it works, great. Doesn't work, try another idea. You know that disputes can be resolved in various ways. A bad example does not mean that you've learned a new way in which it cannot be resolved. And institutional arbitrations give you that flexibility to play around with that. The best example has been an emergency arbitrator. I was involved in the matter that went to the Supreme Court. And I have to say this, I would point out Justice Nariman's own views. He says it helps us because it takes time off from the time we would spend here to give access to justice for someone who deserves it, as opposed to a party who has money to pay for it and can get its justice in terms of a contract that it agreed to. And I can't believe that that can be said to be a bad idea. In fact, it's a great idea for India because if we are able to play it out, it's called Atiti Devo Bhava. Come to my country, arbitrate here, and I will give you a fast-track enforcement with money on the interim stage itself. Very few countries have managed to do that without amending the law. We've managed that through judicial intervention and innovation. And I think it's a great idea whose time has come. Seat your arbitrations in India, despite what may be the experience. Insulate them through using ICC because they will surely they'll ensure that the award is kosher. And the people there are all honorable men and also available men. And last but not the least, it will ensure that the quality of the award speaks for itself, because what Tejus will speak to is what goes on behind doors to ensure that you have the best fit of impartial, independent, and intelligent arbitration specialists coming in. And that gives you the 3 I's which will answer the 3 E's and lead to a lower cost of doing business. Thank you, sir.
Thank you, Mr. Singh. Very well said, that 3 E's, efficiency, economy, and effectiveness. And a point which he made, that arbitral proceedings are actually supplemental to dispute resolution. And that's where the hub lies. That's the nub of the issue. He also said that party autonomy, something like sandboxing, learn from your experiences. Very well. Somebody who has been in charge of or associated with an institution which is dealing with institutional arbitrations, he is our next speaker. He has had rich experience. He is now the Director, South Asia ICC International Court of Arbitration. He must have had experience on a number of occasions coming from multiple examples as to how and to what extent institutional arbitration could be the solution which will take care of all these infirmities. So may I now invite Mr. Tejus Chauhan to share his views in the matter. Please, sir.
Thank you, Justice Lalit. Good morning, everyone. And the topic is institutional arbitration, the solution, is a topic where we've discussed a lot. But last night at 2 in the morning, I had the good idea of going to ChatGPT because everyone's talking about ChatGPT to get a sense of whether institutional arbitration is the solution. And ChatGPT gave me a very good answer in 3 paragraphs saying that it may be the solution. But of course, we will not rely on ChatGPT, and we're talking about whether it is actually the solution. I will speak from my experience at the ICC and what we see at the ICC. And if I was to give you some numbers in what we've seen over the last 10 years, it does indicate that there's a growing preference for institutional arbitration. At the start of 2000, ICC had about 300, 400 cases, which went to about 900 till about 2020. And this is not just the ICC, but there are other institutions also which have seen an increase in the caseload. If I speak about economic sectors, ICC is known for handling construction, energy, the big billion-dollar disputes. But the economic sectors that are represented in ICC come from life sciences, come from pharmaceuticals, come from insurance, come from trade. And these are the sectors that we see at the ICC. So again, a very good indicator of the kind of disputes that we're seeing at the ICC. If I talk about amounts in dispute, a lot of people say that, institutional arbitration, international arbitration, we need to choose an institution only if the amount in dispute is a high amount in dispute. But in 2021, the ICC handled disputes from amounts ranging from $9,000, just around $9,000, to $27 billion. So on the lower end, $9,000, somebody was really angry and somebody wanted to prove a point, where $5,000 is the filing fees. But again, institutional arbitration works both ways. If you look at the parties, about 20% of the caseload that the ICC handles are purely domestic cases. So we've handled cases which are 2 Indian parties, arbitration seated in India, in Delhi, Mumbai, Hyderabad, Chennai. So this is what we see in terms of the numbers at the ICC, and I think this is a very good indicator of why institutional arbitration works and why it may be the solution. VP has touched upon time, cost, etc., and I'm sure that we can address that because those are again concerns. But again, I always cite this study on costs. People say that institutional arbitration is expensive. Institutional arbitration takes a large chunk of the fees. There's a very good report at the ICC on saving time and costs in international arbitration. And if you were to read that report, there was a study on the number of arbitrations that the ICC received. And what the result of that was that if every $100 that is essentially being spent on an arbitration, about $82 is legal fees. So it's going to the lawyers in the room. $16 is the arbitrator's fees. And $2 is the institution fees. So this whole argument about this institution being more expensive.
Speaker that we have listened to today has harped on these ideas. We have had the inputs coming from 3 different strata. Number 1, the employer himself, party who is appearing before the arbitral proceedings. Number 2, the counsel who represents the parties at every level. And number 3, somebody who represents the institution itself, the Institutional Arbitration Center. Now, I just want to know that what is the experience, and we would certainly, perhaps I think all the participants who are gathered today would like to know, that on one side you have the ad hoc arbitrations. At times people say that ad hoc arbitration gives you so much of leverage to look for the best possible talent. So therefore, that's one advantage which some people advocate in favor of what is called the ad hoc arbitration system. At the same time, those who are the proponents of the other idea, they say that institutional arbitration gives you element of great consistency, element of certainty, cost effectiveness, and immediacy of action. Now, I would like Ms. Chinoy to impress and give us the ideas. She must have had, her group must have been exposed to ad hoc arbitrations at some stages, and now the shift towards institutional arbitrations. So what are the advantages as against the traditional idea of ad hoc arbitrations? Can I now ask Ms. Chinoy to let us know her views in that matter?
Certainly, sir. So you are right. I have seen both sides of this coin. I have seen ad hoc and I have seen institution, and I have then therefore been able to compare them. There are definite advantages and disadvantages to both. But from my perspective, the ad hoc, there is an ad hoc that I started when I started my career at Shapoorji about 5 years ago, which is still continuing. There is an institutional arbitration, well, that started maybe a year or so after I joined, which has completed. Yes, there were differences. There are differences in those disputes to play around in terms of what the procedure would have to be, where they could or could not ask for time, where the delays could be. And there was a marked difference for me in the ad hoc versus the institution. That's definitely one of them. The second thing that I found is at the end, and this is only in the institution because in the ad hoc I still haven't got that award, but in some of the ad hoc, the awards that I have to enforce, they will necessarily generally go through the challenges of the court. That's a system that we still have to get over, both in our mindsets, the lawyers' mindsets, courts' mindsets, everybody. So we do go to court on those challenges, and when I see those challenges there versus some of the institution, the time taken in an ad hoc is a little more, whereas when the court sees that perhaps it's an institutional one, maybe there's not that much scrutiny. But I'm wrong again, that may just be my experience. That may not be across the board. Maybe I just got lucky there. But the institutions themselves do sometimes, or in some cases, scrutinize these awards to see that they meet certain requirements, that there is a minimum threshold so that when it does go to court, the challenges are not that effective against it, that it is easier to enforce. And that, to my mind, at least gives me comfort that at the end of the day, when I have played my entire arbitration out and I have something in my hand, it is not, again, something that I have to rework. It's just a matter of maybe a small, insignificant amount of time. And that, again, is a big difference to me in the ad hoc. That scrutiny at that level, at that award, does not exist. At least to date, it does not exist. And that is something that I think the ad hoc system will find difficult to overcome, because I don't think that there's that oversight and we haven't got legislation to create that. So at least to my mind, these two are two big topics for me, the delay and then the certainty. Costs, yes, costs again in the ad hoc arbitration, they're not that easily given. That mentality that costs should be given, it still does not exist. Whereas in an institution, you have set procedures, you have methods in which I have to submit certain costs, the manner of which it has to be done. It's laid out, it's worked upon, it's actually regulated by them. So again, in that sense, if I have gone to arbitration knowing that I have a valid claim, knowing that I have had to fight for something that should have come to me, and therefore those costs should also come to me, and I don't have to fight for them again, or don't have to prove them in an unnecessary manner, then again, to my mind, that is a big significant plus in an institutional arbitration. So these things, these are not minor, especially in arbitrations like mine where they're large and they're onerous, where, as he said, he pointed out, 82% of the costs are legal. 82% of a big arbitration, the costs are legal. 16%, as he said, is the arbitrator's cost. I would like some of these back if I was in the right. And I don't want to have to refight them or explain myself in an ad hoc why I should be getting them. It should come to me if the decision is going to be in my favor. So these are some of the things that I do see in the challenges facing ad hoc versus.
Thanks, Ms. Chinoy. Now, very beautiful and subtle distinction that perhaps I'm not even saying as a matter of certainty or for all times to come. Ad hoc arbitration may have an element of flexibility as against, in the name of quote unquote consistency, there may be slight rigidity when it comes to institutional arbitration. So is that really so? That flexibility as against rigidity or consistency? Now we will ask Mr. VP Singh what his experience in that field has been and whether according to him the ad hoc arbitrations are certainly sort of, must give way to the present day scenario, which is the institutional arbitrations. Yes, Mr. Singh.
Thank you, sir. I do believe that there cannot be an absolute answer for either side of the proposition. So let's be clear about horses for courses. Can the case that Tejus talked about, $9,000 claim for a $5,000 filing fee, be the answer? The answer is definitely not, because that shows someone was really mad and did not want to get even. He just wanted to show that he was mad. You have these cases happening on a day-to-day basis. Let's take a simple situation. We're all touched by e-commerce, from the guy who delivers your food to the guy who delivers your shirt. Would all be on an app. Now, these cannot go to an institutional arbitration because institutional arbitrations just don't have the bandwidth to handle this volume of work. So you need to right size what you send to an institution. Because if you don't right size it, you are always going to find the problem of averaging. A good solution becomes an less optimal solution when it is applied in an inapplicable construct. And that's what will happen when you go into consumer disputes, when you go into what you would call small claims. They've tried to figure that out through models such as expedited hearing on pure memorials alone, without evidence, expedited summary procedure. But we've all grown up to the fact that we should have more of a say, ye dil mange more, which is why I have not seen Indian parties opt for it. And that's been the reason why ad hoc may be the answer to those claims. The next piece that you have to keep in mind is with respect to flexibility not being applicable to a institutional setup may be an overstatement, because the institutional setup itself says all these clauses are subject to the agreement between the parties. So it's effectively like whichever part of the world, all my analogies come from food because of my size. So if you are from Gujarat, you may want to have a little bit of chini or sugar in your dal. It may not work in another part of India. A flexibility is therefore provided where it says that you have a choice to add. They actually provide for it. They say that subject to agreement between the parties, these are our rules of engagement. And engagement can be such that you say, okay, when you are going to hear me out, you're not going to give me a time less than 3 weeks. No one's going to turn around and say no, because parties agreed to it. And that's what the concept and the beauty of the concept of party autonomy is. You pay for what you agree to. So no one can say that it's unfair, it's underwhelming, or it's overwhelming. It's what you wanted. And what you do need is someone like Zarina to sit down and tell you that be very careful what you wish for, because risk has to be managed. It has to be managed within time and for a reasonable effort, which results in what you would call a predictable result. Everyone hopes that we've got it right. There are days when we get it right, and there are days when we wish we had got it right. But what experience teaches you is you do have the flexibility. Just be careful about how flexible you want to be, because when these rules are put together, they take inputs from the world, the best practitioners in the world, to give you an answer. And they deal with situations which you may not contemplate initially when you're contracting, but which visit you. Multi-party contracts and appointment of arbitrators. You try and enforce, Zarina may have to enforce an award, say, in Paris. And there you have the Napoleonic Code's idea of what is equality and the right to deal with equal right to appoint. And the Dutko principle which led to an award being set aside in a multi-party arbitration merely because one of the parties was not involved in the appointment. For that, institutional setups have put in place what I call clear vaccinations. What is the vaccination there? The tribunal will not be appointed by any party. The institution steps in, says, I dissolve the names of the parties. It may just end up appointing the same names themselves and appointing a third name. But what it does is no one then falls foul of a particular jurisdiction, which you may or may not believe was relevant at the time when you contracted, but where you may find money. You're seeing a lot of action in India today trying to enforce awards against Russian companies. No one ever thought Russia was anywhere in the predicament for enforcing awards from other courts against Russian parties, but in doing so, people thought London would be the place, Geneva would be the place, Paris would be the place. No one thought New Delhi, but everyone's now thinking New Delhi. So you do have an evolving setup and you do have institutional muscle memory, which ensures that that flexibility is built in. But you have to be careful about why you want to tinker with it. And if you have good reasons, please go ahead and do it. It's like your the optional booster dose in a COVID vaccination. Whether you're an anti-vaxxer or a person who believes 2 is enough, you have that choice. You can choose not to take the third one. So that's where I believe, sir, that there is flexibility and that brings about accountability. But be careful what accounts you want.
Well said, Mr. VP Singh. Flexibility brings in accountability. Very well. Now, I will ask our next speaker because he has enough experience on the front of institutional arbitration as to what exactly is the march in other jurisdictions. Because we see that the march in last about, say, 10 years or so, and even the shift in the statutory provisions that yes, encourage institutional arbitration. So if that's the shift, if that's the ethos, if that's the idea which is now prevailing in major parts or in some of the jurisdictions, how has this problem been taken care of in other jurisdictions? Because he is now part of what is called International Arbitral Center. So may I ask Mr. Tejus what exactly his experience in that front has been?
Thank you, sir. I will speak about Singapore first because I am in Singapore now. And if you look at the Singapore story, Singapore is now a very preferred seat, and especially for Indian parties who want to arbitrate in Singapore. And if we go back to the ideology of the Singapore government, we're always talking about hardware, hardware, hardware. But there's also software that builds a good seat. So in Singapore, the courts were sensitized from the very beginning about institutions and about awards. And if you look at any good seat, there is minimal interference from the courts in arbitration. Good seats also have institutions linked to them. So there are several institutions international which come from good seats. One of the other things that we notice is that there is a growing need and popularity of institutional arbitration, sir. There are certain jurisdictions which are far more developed when it comes to institutional arbitration and the know-how and adapting institutional arbitration. There are certain jurisdictions in Asia which are still coming up. So there are jurisdictions like in Asia, there are jurisdictions like Indonesia, Vietnam, where there are still issues with institutional arbitration, with enforcement. And Singapore is a very good example. But then if you go Paris, Geneva, London, Switzerland, etc., are good seats or safe seats, as we can speak. This is something that we see on the international front. So, and if I could just touch upon accountability, because I wanted to touch upon that. In the end, institutions are service providers. They're providing a service which is administration of your disputes, oversight over your disputes. And you're choosing an institution, I think, for flexibility, transparency, and accountability. And if the institution is charging you a fees, which is the administrative fees, it has to be accountable towards that. And the accountability is in two forms. There is accountability on the part of the institution, and there is accountability on the part of the arbitrators that are acting under the rules of the institution. So several of the arbitrations that are currently underway at the ICC or have taken place, we see delays on part of the arbitrators. And this is where accountability comes in. So ICC has provisions where we would reduce the fees of the arbitrators in case of unjustified delays and give it back to the parties. When we did this, the question was that ICC, who's ICC to reduce the fees of the arbitrators? They have no idea about what goes in an arbitration, etc. And what happens if the ICC itself is delayed? So ICC, it's at the same time, there is provision where if there's a delay on the part of the institution such as ICC, the parties like Zarina, for example, can write to the ICC and say that it has been 6 months since this tribunal has not been constituted, and I expect a reduction in your administrative fees. I think that is accountability as well. And that is one of the reasons that parties choose institutions, because they want that oversight. And take the example of an ad hoc arbitration where the parties might be reluctant to go to the arbitrator and say that we've not had a hearing and we would really like a hearing, because the arbitrator may be busy. And that is where the deputy counsel, the counsels of the secretariat would step in to ensure that the arbitration is on track. So, yeah.
Thank you, Mr. Chauhan. Now, taking the discussion further, 2 points which were made, one by Mr. VP Singh, about this vaccination. Very brilliant idea that, institutional arbitration must provide for minimum certain guarantees. So therefore, at least, I go home with that assurance, with that confidence, that in case anything, any infirmity or anything happens, then at least I am covered to a certain extent. So therefore, one part is vaccination. Second part which was made, the point which was made by Mr. Chauhan, is this minimal court interference. On both these issues, now, one of the ideas, I'm just throwing this topic for discussion, many a times disclosures become the thorn in the flesh. At times in ad hoc arbitration, there are not sufficient disclosure by the arbitrator. And the arbitration proceeds for a certain extent or to a certain extent. And then thereafter, the parties become aware of certain kind of factual scenario. To what extent institutional arbitrations will act as vaccinations, and they will ensure that, or at least that minimal guarantee will be provided by, in case party goes through the umbrella or through the door of institutional arbitration. Can I ask Ms. Zarina Chinoy, what is her experience on this front?
This one is a bit of a dicey question, isn't it, sir?
Yes.
So, when you say in terms of vaccinations, and then you ask also in terms of minimal guarantees, in some ways I want both, right? So how do I get both, sir? I think I should have asked this question to you.
My days of being judge are over.
Your days of us are not over, sir. You're still up here with us. So these are practical challenges. At the end of the day, again, there's a lot that has to go into each of these before that question can even be answered, and quite frankly, the facts of each case have to be scrutinized for each of these answers. But at the end of the day, when I want that accountability, when I want that result, what that vaccination will give me, but what I want is that result, at least that certainty, that fairness, that impartiality, that ability to enforce that award, that I will look to Tejus. And I want that from the institution, because yeah, I am paying for it, quite frankly. Whatever it be, the breakup, at the end of the day, I am paying heavily for it. So yes, so I do look at him quite stringently. And as he has touched upon it, there is that ability for me to write to the ICC saying that yes, either you've delayed, the arbitrator's delayed, or there is some infirmity in the award, etc., that we can try and find a solution to and correct. And that, to me, is a significant step in me being able to get this justice that I want faster, to get that award, the money, at the end of the day, those costs faster. So yes, the institution provides that mechanism. We do use it. We have to be very careful how we use it. We cannot overstep it. I mean, there are limits to everything. You do not have indefinite rights in life, right? So these are sometimes also strategic, sir. So we have to look at when we want them, how we want them, and more particularly why we want them, sir.
Thank you, Ms. Zarina. Now, Mr. VP Singh said, and I like that expression, vaccination, correct, to afford minimum protection, minimum guarantee. He also said that, very well, let the procedural part be taken care of. Why should I put the entire CPC into my contract? So therefore, I need not bother about that. There are internal rules, regulations which govern the kind of arbitrations which must be, the way they must be undertaken, the way the issues be dealt with. And the institution will take care of those issues. So whether the institution by itself, so far as affords that kind of clear vaccination or protection in all possible eventualities, of course, yes, it cannot afford. Theoretically, there could still be certain infirmities. You try to generalize, to try to regulate to the extent possible in a general fashion. But I would like to ask Mr. VP Singh, has there been any experience where perhaps I think you have found that the institutional framework of procedure has been found to be wanting in certain directions or certain areas?
I remember this book called Wonder, where the tagline is, if you have to be correct, if it's a choice between being correct and being kind, choose kind. So I'm going to go with kind, and I'm going to put it in this way. The biggest problem that we see with large infrastructure contracts is the government is a counterparty. The government has its own system of institutional appointment, which has been a feeder for a lot of lawyers to get into court and make new jurisprudence on the concept of conflict. Maybe we could re-look at this, saying that if you have a panel of people whom you choose from, choose a panel which also has people from private sector. Get all the vetting done that you do, because then you will have a more wider panel. The second thing that you look at is institutional infrastructure and capability. As I pointed out, sir, that with respect to consumer disputes, you can't take consumer disputes into an institution. As much as the institution will be happy to say we've got the numbers, they'll just fold over because the sheer numbers will kill them. And we're seeing that with a number of domestic institutions which are favored by the government, which means that they're already bursting at the seams. So it's a time for us to look at new champions. And we could have 2 or 3 specific players. You could have the DIAC, which is here. You could have the MCIA or Nani Palkiwala. Choose any center. Choose a center of eminence which will remain when the dispute takes place. Because that's very important, because that leads to its own uncertainty. But more importantly, in international contracts, why don't we choose, say, in the standard form of contract, say the ICC clause, which used to be in the original standard contract at times. So if you see the NTPC Singh judgment, that's what is the issue there. So A, you need institutional bandwidth. B, you need more institutions. C, you need a wider base. Because if people have equal representation or a panel to choose from, they may not go to court, because no one really wants to go to court other than lawyers. And Zarina has already told me that it's not ChatGPT that I need to worry about, it's her. So in such a situation, sir, this is what I would say. So we need institutional infra, we need institutional mindset, and we need internationalization of the mindset. These are 3 things that I believe, my 3 eyes, I seem to be going back to the letter repeatedly, but these are my 3 eyes for this answer.
Thank you, Mr. VP Singh. Now, one area which was touched upon on the earlier occasion by some of the speakers was cost effectiveness. Of course, yes, the institutional arbitration must be cost effective. That's the fulcrum which affords greater confidence. But at the same time, one point which was also made by one of the speakers was that the costs must be real-time costs, not some good archaic kind of equations that the counsel's fee is supposed to be only 10,000, which in reality today far exceeds that sum. And therefore, the example was given of Delhi High Court on the original side where the real-time costs are actually guaranteed. My experience has been, this is what I have heard, that perhaps the Singapore model is successful. Why? Because the costs are real-time costs. So therefore, I will ask Mr. Chauhan, what exactly is the idea so far as costs being real-time and whether the institutional arbitration also makes a provision for that so that that becomes a good kind of incentive for people, those who are aspiring to go to arbitration as a solution to the dispute. Should they not be guaranteed? Should they not be afforded real-time costs? So what is the view of the institutional arbitration centers on the point, Mr. Chauhan?
Thank you, sir. Taking cue from VP, who's been talking about and giving very good examples of food, I'll also draw an anecdote, but about insurance and about health. So when a party is subscribing to an institution and where they're comparing costs, think of it as insurance. When you're buying insurance, you're not thinking about, oh, I'm not going to fall sick. Maybe you do, but if you do, you want the best insurance. You want an insurance which is universal, international, which has a good cover, which does not have many exclusions, etc. So when parties are looking at costs, what institutions provide for is a cost calculator. The ICC has a cost calculator where you go to the website, you put in your amount in dispute, you select whether it's expedited process, whether it's ordinary, the number of arbitrators, and it will give you a sense of how much the institution will charge as administrative fees and what will be the fees of the arbitrator. There'll be a minimum, average, and maximum. ICC usually fixes the costs at average. And this gives you an indication of this is what I'm going to pay the institution, but bear in mind that this is not inclusive of legal fees, which could be anything depending on the law firm that you're going for. VP is, of course, very expensive. So this gives you a sense of the cost and allows you to estimate for what is the cost. And I think it's not just the ICC, but other institutions also that provide for this, where you can draw a comparison. But again, there's no certainty in an arbitration in the sense that this is just to give you an idea. Every arbitration is a different arbitration. It also depends on whether there's a settlement, what time do you settle, what is the amount that is returned to you, etc., so on and so forth. So these are the factors that I think often come into the play when thinking about costs.
Very well, ladies and gentlemen, we come to the close of this particular session. It has been very instructive for me. I have been out of the work as a counsel, so therefore it was something very, very refreshing to hear the viewpoints which are presented by the co-speakers here. I go home as a person who has been enriched on 2-3 fronts. Number one, according to me in last 10 years, the figures show the shift towards what is called institutional arbitration. We have learned from our experiences. 1940 is our first arbitration law. Even before that, there used to be arbitrations. The codified UNCITRAL model comes in 1996. We have had almost about, say, 27 years under that model. We have learned from those models. 2019 came the amendment, which gave some kind of elbow room to institutional arbitrations. Our experience shows that so far as cost effectiveness is concerned, confidence building apparatus is concerned, and consistency is concerned, perhaps institutional arbitration affords a better choice. Of course, there are no 100% solutions on either side. What we try to do is that the least possible kind of infirmities, system which has least possible infirmities, we try to opt for that. Apart from having these cost efficiency and other things, number one is, as Mr. VP Singh made a point, that I need not make provision for every single procedure or aspect of procedure. There is this particular institutional arbitration which has internal rules of governance, and it makes provision on every single facet of the matter. So therefore, I get what is called a ready-to-cook kind of recipe straight away. So that's the other advantage of that. And the third thing is, according to me, there could be leeway for or the room for domain experts. There are multiple kind of situations which we may not even contemplate to begin with, and those the litigation may then unfold. And perhaps I think institutional arbitration would certainly have that kind of expertise to make available the domain experts in the field. Look at it from any perspective. The idea appears to be that there must be quick resolution of dispute. If you are thinking in terms of having an alternate dispute resolution, then that dispute resolution must be quick, fast, inspiring confidence. And these elements, to my mind, and according to my co-speakers also, and I take this liberty of saying that according to us, institutional arbitration affords far better choice than the ad hoc arbitrations. Thank you, ladies and gentlemen, for having you participate in this particular session. We enjoyed it as much as you must have enjoyed listening to us. Thank you so much. Thank you.
So thank you so very much for setting the tone right at the very first session of this amazing conference. May I once again request the audience to thank this esteemed panel in the usual way. Ladies and gentlemen, there is a 10-minute coffee break at the coffee lounge on the 7th floor. And just like DIAC arbitrations, the DIAC and the DAW arbitration